here is Raana.
Thanks, Rosa. Hey everyone, and thank you for joining us today. I am really pleased to see the diverse group of folks who are on the line, and I will do my best to tailor all of the information that we have for you today towards the implementation for folks who are coming out of law enforcement, our medical folks, and our campus-based folks. So again, my name is Raana Simmons, and I am the Director of Policy for the Colorado Coalition Against Sexual Assault. The way that we're going to kind of work through this today is just go bill by bill and discuss, what happened. Did this bill get signed into law? Was it PI'd, meaning postponed indefinitely, or killed? What is the implementation of this bill going to look like? Who is this going to impact? And again, as Rosa said before, if you have any questions, I am going to open my little question box right here so I can follow along with you all, but we will try to save questions towards the end and try to answer that for folks. So moving forward, there we go. So this is just a general summary of selected bills that CCASA prioritized for the year. So this is anything that had a really strong nexus with sexual assault. And we're going to start off with those bills that had the strongest nexus. And the goals for today, again, is just to review the outcomes of those priority bills, discuss impacts and implementation, and then I guess really the best question is, where do we go from here? Where do we go to ensure that survivors of sexual violence are taken care of, are supported by the systems that they turn to when they report sexual violence? So this is what we're going to be jumping into right off the bat. The first being the statutory change to the definition of child abuse and neglect to include sex trafficking of minors. So that was House Bill 1224. That was signed into law on April 15th. So that did pass. And essentially what we're talking about here is this bill recognized that child sex trafficking is a violation of a child's rights and well-being, and that it denies children the opportunity to reach their full potential. What we know about sex trafficking is that it has devastating consequences for children, including long-lasting physical and psychological trauma, disease, drug addiction, unwanted pregnancy, malnutrition. There's a whole host of negative effects of sex trafficking on children. And what this statutory change does is bolster child welfare's response to protect Colorado's most vulnerable residents, which are children. Implementation of this is kind of interesting because there's a segment about third-party abuse or neglect, and I'm actually going to read that to you right out of the bill. But essentially, if a county department of social services suspects that a child is the victim of human sex trafficking, they have to notify local law enforcement. And so from the legislation, it talks about in cases of third-party abuse or neglect, a county department of social services may, but is not required to interview the suspect or may determine a finding. So law enforcement folks that are on the webinar right now, this is probably of interest to you. It says if a county department elects to interview the third-party suspect, it shall, meaning it's mandated, to first confer with its local law enforcement agency. So I think, and we can have some discussion around this too at the end or now if folks want to type in questions or comments into the box. What the implementation of this looks like is really local law enforcement, a strengthened partnership between local law enforcement and the child welfare system, where case managers who are child welfare investigators who are coming out to these cases are really working with law enforcement and the expertise that law enforcement has in investigating and even interviewing. I mean, the way that this is written says that a caseworker can interview a suspect. So what we're looking at here, I think at a local level, is just increased training, increased partnership between the county and law enforcement to make sure that perpetrators are held accountable and that children are kept safe. The limitations of this specific bill is that while it makes a statutory change to include sex trafficking, it does not and excludes labor trafficking of children. So, kind of what we're thinking this may be is an incremental change in statute that might be the pathway to including child victims of labor trafficking under the statutory definition of child abuse and neglect. So right now, this change is only specific to sex trafficking of minors, not labor trafficking. So perhaps more to come with this bill. Next, we are going to move on to House Bill 1260, which I believe originally was House Bill 1072. I could be wrong. That bill was PI'd and then 1260 was introduced. And what this is to extend the statute of limitations for felony sex assault. So when the bill was originally introduced as House Bill 1072, it sought to eliminate the statute of limitations for felony sex assault cases, such as in sex assault cases on a minor, on a child. Has no statute of limitations. The original intent of this bill was also to eliminate the statute of limitations for adult felony sex assault cases. However, that met some opposition, and the bill sponsor chose to PI her own bill and then to reintroduce an extension versus an elimination. And this particular bill, which was sent to the governor's office just a few weeks ago, last week on the 11th, so it passed, yay, yay for survivors. This extends the current statute of limitations, which is 10 years, to 20 years in cases without the collection of DNA evidence. The reason that I underlined this part about without the collection of DNA evidence is because currently with DNA evidence, there is no statute of limitations, but without there is. And so this bill extends that statute from 10 years to 20 years. Also, something pretty interesting about this bill is that it addresses what we are calling a loophole in the current child sexual abuse statute of limitations. There is, and as you see here, children ages 15 to 18 years of age, to allow them to have greater reporting options. The way that the statute is currently designed is that there is no statute of limitations for children under the age of 15, but for those children that are 15, 16, 17, they fall under the adult statute, which was 10 years and now will be 20 years. So I'm just going to read you a little bit of information for the types of charges that will be affected in that age group, that demographic of 15 to 18. So at this point, children between the ages of 15 and 18 who are victims of the following crimes are impacted by this loophole: sexual assault on a child by one in a position of trust, aggravated incest, human trafficking of a minor of sexual servitude, sexual exploitation of a child, soliciting for child prostitution, pandering of a child, procurement of a child, keeping a place of child prostitution, pimping of a child, and inducement of child prostitution. So as a result, a 16-year-old victim of sexual assault on a child by one in a position of trust or aggravated incest is currently subject to the 10-year statute of limitations, requiring that they pursue criminal charges in far too short a period of time. However, now that this bill has passed, it supports children who are survivors of these sexual crimes to have greater access to reporting options and greater access to holding perpetrators accountable. So I think this is a really victim-centered and trauma-informed piece of legislation that was passed at the Capitol this legislative session. I mean, we know that there are many reasons why victims of rape do not report sexual assault. We're talking about feelings of humiliation, denial, shame, self-doubt. Sometimes victims need decades to even admit that the assault occurred, let alone talk to, you know, a systems-based person or a community-based person or a campus-based person about what is perhaps the most traumatic event perhaps of their lives. And ultimately, we know that survivors report when they're emotionally ready. You know, and so not even just from the perspective of this being a victim-centered piece of legislation, but from the perspective of those folks, those systems-based folks, those prosecutors who are responsible, who are charged with protecting citizens and with charging this crime. Research indicates now that fewer than 6% of reported rape cases are prosecuted. And so what this does, this expansion, it allows prosecutors more time, it allows victims more time to come forward, and it allows prosecutors more time to actually go ahead and bring these cases forward and press charges in sex assault cases. So this was really important. This was championed by Representative Fields. And we had many survivors come out and testify in this particular hearing. I believe the House hearing was something to the effect of 7 or 8 hours long, and we had a lot of support from you all, from our victim advocacy community, from our prosecuting community, from law enforcement. We had a lot of folks behind this bill. We had survivors share their story, and we really appreciate everybody who came out and everybody who stuck with us, because this is a very significant piece of legislation in the state of Colorado. And on that note, we're going to pause right here, and I just want to do a second poll really quick, asking folks if you took legislative action this session, and what was your, let's say, preferred method of legislating on behalf of survivors. So we're just going to do this quick poll and see if folks felt comfortable calling or emailing legislators, if people testified at a bill hearing. I know there were lots of folks who came to 1260, anyone who shared the urgent policy action alert, watched the YouTube policy podcast, and thank you for those who watched the policy podcast last week and tuned in today. I appreciate you. And then any folks who perhaps did not take action this legislative session. So I see some folks are answering, and we're going to give just a few minutes. You know, the reason why we're asking these questions is really for our internal use, so that we can design effective grassroots strategies to engage you all in the legislative advocacy process, and see what's working for folks and what can be improved. So I see the numbers are up, and I'm going to go ahead and share those. It looks like the urgent policy action alert and the YouTube policy podcast were favorites, so I promise to make more of those as we go through the 2017 legislative session. Thank you for participating. So moving forward, I think, there we go. Thank you, Rosa. So next we are going to talk about House Bill 1058, misuse of electronic images. And I don't know how many folks were aware of what happened with this bill. It was highly sensationalized in the media, and for those of you who are a part of the CCASA Policy Committee and our members, I'm sure that you were up to date with what was happening with this bill, because it seemed to change course faster than the wind blows type of thing. This bill was amended several times. There were last-minute stakeholder meetings. There were a variety of interest groups who got on board. Just to name a few, we had Amy Hasanoff. She's an assistant professor of communication at the University of Colorado, Denver, and she's also the author of Sexting Panic, Rethinking Criminalization, Privacy, and Consent. She was kind of our local expert here. We were very grateful for her research in the arena of sexting. We had the Criminal Defense Bar, the ACLU, we had Colorado Youth Matter, One Colorado, Rocky Mountain Children's Law Center. There were so many stakeholders who came to the table on this, and I think what that says about us as a community and us as a state is that people care about sexting, and they are trying to come together to find the most appropriate, age-appropriate, trauma-informed, accountable legislative fix possible. And I think that these conversations have, I mean, they certainly have been happening around the country. They have been happening here in Colorado for quite some time now. And because of the complexity of this issue and because of the passion that folks have about this issue, it is one that requires, I think, a lot of discussion, a lot of different viewpoints, and that certainly happened with House Bill 1058 this legislative session. We'll just start off by talking about the bill. This was postponed indefinitely, meaning it was killed on April 25th. Unfortunately, CCASA monitored this bill for a short while in the beginning, and ultimately we chose to try to make an amendment that we thought would honor survivors of sexual violence, of teen sexting, but also hold perpetrators accountable in a way that is sensitive to juveniles and teen behavior, teen exploratory behavior, and abusive sexting. And so originally we sought to amend this bill, and ultimately we opposed this bill. And the reason being is for this piece right here that I believe I have listed for you, it says, the bill creates a misdemeanor offense and to include a sexually explicit image of himself or herself or another juvenile. And so the problem that we saw with that was that a survivor, let's put this in the context of teen dating violence. So you have two partners in the relationship. One partner coerces or intimidates the other to take a sexually explicit image of themselves. That victim of teen dating violence takes a picture of themselves because they're being intimidated or coerced, sends it to the abuser in the relationship, and then a third party finds the picture, or the abuser disseminates it out to the rest of the school, or somehow this image is found. And what this bill would have done would give equal punishment to the victim of teen dating violence because that person took a picture of themselves, and to the person who intimidated or coerced the picture to be taken in the first place and then further disseminated. Both parties would have received equal treatment and equal accountability through this law, or through this bill. And so that was where we found it to be problematic. We expected that written this way, there would be a chilling effect on reporting rates, right? So if a victim thinks that coming forward to law enforcement or seeking help in any way is going to indict them of the same crime, then they're likely not going to come forward. And ultimately, CCASA cannot support a policy that is designed to protect survivors that also has the potential to harm or criminalize them. And so, there's a couple of factors that play into this. For example, the age of consent law in Colorado is 17, and then there's also close in age exemptions, which means that, at 17, you are legally old enough to consent to sexual activity, and the close in age exemptions mean that if you are within a certain age range, let's say a 16-year-old and a 17-year-old, then the consent law also applies to your relationship. So what this bill would do is create a situation where two 17-year-olds are allowed to have sex, but they are not allowed to possess pictures of each other naked. And so I think what happened with this was, CCASA is not advocating for teen sexting, but what we were advocating for was to protect survivor rights, and that possibly teen sexting should be addressed through a different system other than the criminal legal system. And what that might look like is education, is comprehensive sex ed. That could look like a whole lot of different things. But we tried to amend this bill. We were unsuccessful, and therefore we had to actively oppose the bill. Now, the impact that this has, that because this bill did not come to fruition, because it was not passed in the legislature this session, prosecutors are still able to charge felony sexual exploitation of a child in teen sexting cases, resulting in either the charge of a Class 4 or a Class 6 felony, and that, if convicted, would require teen sexters to register as a sex offender and complete sex offender treatment. So essentially, we're right back to where we started, where prosecutors have, one tool in their tool belt, and that is a felony sexual exploitation of a child charge, which is not designed for the behavior of teen sexting. And that was where this idea of a misdemeanor came into play. We just thought that it wasn't trauma-centered, it wasn't trauma-informed, it wasn't victim-centered, and for that reason we opposed it. Now, there was another argument that was made by proponents of the bill, by people who supported this bill, that sounded like language that if a juvenile had not originally taken a picture of themselves in the first place, then the crime of abusive or malicious sexting could have never occurred. And I don't know if any of you right now are kind of smirking or maybe rolling your eyes, but that sounds a lot like the logic we used to hear and sometimes still hear about she would have never been raped had she not been in that bar by herself, or she would have never been raped if she had watched her drink and would not gotten roofied, or she would not have gotten raped if she weren't wearing that short mini skirt and asking for it, right? I mean, that type of logic, that if the youth had not taken a picture of themselves to begin with, regardless of if they were coerced or intimidated or it was consensual sexting, then the crime could have never happened. And so just philosophically, CCASA cannot support legislation like that. And the reason that I'm kind of taking a little bit longer on this one than the others so far is because this is a policy issue that is sure to resurface until Colorado is able to create a better legislative fix than the one that currently exists, which is that felony charge. And so we will be sending out, CCASA will be sending out a policy priority survey to our full membership to determine if this is a policy priority that we want to take on for the 2017 year. The thought being is that if we can get out ahead of this, then we can create something that both protects survivors, protects consensual sexting, but criminalizes the behavior of abusive or malicious sexting, which we think is the problem. And as for consensual sexting or sexting within the context of teen dating violence, that perhaps some educational efforts can come into play, and we can have conversations with teens about the permanence of taking naked pictures and what risks are, but we don't need to be criminalizing that behavior. The behavior that does need to be criminalized is when a juvenile's picture is disseminated without their consent, right? In the context of let's just say two people in a relationship, boyfriend, girlfriend and boyfriend are in a sexual relationship, they're consensually exchanging photos, they break up, and one party sends naked photos without consent of the other because they're hurt, because they're seeking to embarrass, because whatever that behavior is, that's the behavior that we need to be addressing. That is the malicious and abusive behavior, not consensually taking a picture of yourself. So more to come on that, and for those folks who are CCASA members, be on the lookout for the priority survey. It's a Survey Monkey. It'll be coming your way and we think that that will be one of our priorities for the 2017 legislative session. Moving on, I think, yes. Senate Bill 075, and this is a bill that has been continuously introduced in the legislature. It comes from research out of New York State and Wisconsin, and what this bill aimed to do, it was also PI'd in late March. What this bill aimed to do was to require the collection of a DNA sample to include persons who are convicted of a specific set of misdemeanor crimes. So I've listed those different misdemeanor crimes for you. There are several other states in the country who are already in the practice of collecting DNA samples for these specific misdemeanors. New York and Wisconsin are the leaders in that. And I pulled a little bit of research just because we think that this may be another area of interest, area of policy that continues to resurface throughout the different legislative sessions. So just to keep this on folks' radar, the U.S. Department of Justice reported findings from one study concerning the New York State DNA database and the National Combined DNA Index System, known as CODIS, where the state's first 1,000 hits meaning cases in which DNA found at the crime scene is matched to someone in the database. So it showed the first 1,000 hits showed that the vast majority were linked to crimes like homicide and rape. But of these, 82% of offenders were already in the databank as a result of a prior conviction for a lesser crime such as burglary or drugs. So what this research is suggesting is that when we collect DNA evidence for quote-unquote lesser crimes such as theft, such as violation of a protection order, such as solicitation of a prostitute, that there is research from multiple states over multiple years that shows a correlation between those lesser crimes and more severe crimes like homicide and rape. And so as we know from our work in sexual violence, from scene exams and from forensic evidence collection, DNA evidence can make or break the outcome of a case. And by analyzing DNA samples, it allows forensic scientists to compare perpetrator profiles against a larger database that both increases the likelihood of offender identification and build a stronger case against the perpetrator to help prosecutors remove violent criminals from our communities. So right now, the way that this has the potential to impact Colorado is that currently there are over 6,100 unmatched forensic samples in the Colorado DNA database. These crimes include homicides and rapes, and the majority of them are against women and children. So if this were passed, the assumption is that many of those unmatched samples could be solved and could link to crimes as serious as serial rapists and homicides. Just a few more statistics for you in regards to this. That same report that was originally stated about New York also had some information out of the Florida Department of Law Enforcement that showed 52% of database hits against murder and sexual assault cases matched individuals who had prior convictions of burglary. In 2006, statistical research collected from the New York database revealed that 34% of offenders linked by DNA to homicide and sexual assault cases were discovered through the submission of DNA sample after a drug, burglary, or petty larceny conviction, with specific figures showing offenders convicted of petty larceny to have been linked to roughly 48 murders and 220 sexual assaults. So I can share with you, I was at this hearing, and what we heard from our district attorneys council, from our DAs around the state, was that this is just one more tool to aid in the prosecution, to aid in public safety, but to aid in the prosecution specifically of sex assault cases where, as we mentioned before, only 6% of cases are prosecuted now. And so this is a pretty significant issue for us, and if it comes back next year, we are likely to support this legislation. So keep this on your lookout for the 2017 session. So next we're going to look at House Bill 1210, Prohibit Conversion Therapy Mental Health Provider. And we took a passive role in this bill, and the reason that I bring it up in this legislative wrap-up is because of the argument that the opposition continuously used and was successful in defeating this bill. What this bill would have done, had it passed, was to prohibit essentially a therapist from engaging in conversion therapy with a patient under the age of 18 years old, so meaning a juvenile. Conversion therapy essentially is talking about gender identity, it's talking about sexual orientation, and what we continuously heard in those bill hearings from the opposition was that they were citing sexual abuse and assault as the reasoning for the need for conversion therapy. So meaning these folks were saying that the reason juveniles perhaps are questioning, stating, experimenting with sexual identity and sexual orientation is because they are the victims of sexual assault, and that is simply not true. So the argument was made that child abuse survivors need access to conversion therapy because gender identity and sexual orientation choices outside the scope of heteronormativity are the result of a sexual trauma. And if this bill comes back, which it may, CCASA is likely to advocate against this rationale and work with stakeholders to support the prohibition of conversion therapy. One Colorado were the folks who led the charge on this. I believe this bill passed in the Senate and died in the House. And so we were kind of maybe surprised or appalled might be a good word that opposition to this bill was using sex assault as a reason for gender identity and sexual orientation. And so we are likely to work with One Colorado next year and take a more active role to discredit that line of arguing because it is simply not true. So that bill was killed on April 11th. And again, if it comes back, we're likely to take a more active role. Okay, House Bill 1345, Sunset Treatment Program for Sex Offenders. So this is talking about the Sex Offender Management Board and their reauthorization. So this bill, there was a lot of back and forth with this bill. This was another one, just like the statute of limitations, where we sat in committee for hours. This was another bill that had a very similar feel. I believe our lobbyist team was there well into the night in the House committee. And essentially, the result of this bill is that it was reauthorized for 4 more years. So the Sex Offender Management Board will remain in operation for another 4 years, and then they will have another sunset review where their work is reviewed and reauthorization is considered again. So this bill, I believe, had something like 23 amendments to it in its first committee hearing, so it was very cumbersome, and there was just a lot to digest and go through. And most of our membership, those amendments that eventually were adopted in the House and then later in the Senate, most of our membership did not find these problematic. Areas such as identification and evaluation, guidelines and standards, the creation of a data collection plan, those were all amendments that were included in this reauthorization, the sunset review. However, the area of concern that we heard from folks was Amendment L014, which was concerning the sentencing of sex offender treatment. So I'm just going to read from you specifically what that amendment says. And again, this is written into the bill. This was adopted in both the House and the Senate, so this will be a new procedure moving forward. it says, quote, "The supervising agency of each adult sex offender and juvenile who has committed a sexual offense shall give an offender a choice of at least 2 appropriate agencies staffed by approved providers unless the supervising agency documents in the file that based upon the nature of the program offered and the needs of the offender, fewer than 2 agencies can meet the specific needs of the offender to ensure the safety of the public. Once selected, neither the treatment agency nor the polygraph examiner may be changed by the offender without the approval of the community supervision team, the multidisciplinary team, or the court." So essentially what this means is that sex offenders are now being given the option to choose their therapist. That was problematic for some of our membership. Some of our members were concerned that through this provision, sex offenders would have the option to cherry pick the easiest service provider who would not hold them accountable. And we believe that those are some real legitimate concerns. Now, the way the bill is written, it says that a sex offender is given the option of two choices, and then after that, they must stick with one service provider. And proponents of this amendment stated that if an offender does not have buy-in or trust in their service provider, their treatment will suffer and their behavior is less likely to change, which seems like a valid argument. However, research disputes this claim, suggesting the argument of buy-in may be plausible for folks self-electing to treatment, but in cases where individuals are court-mandated, this variable has no impact on treatment outcomes. So that was a concern of folks, and we are going to monitor that and see kind of what that looks like in the field. I believe SOMB will also be monitoring that to see what that implementation looks like and see if if that's going to be successful for sex offender management. So more to come on that. Again, it was reauthorized for 4 years, and SOMB, or the Sex Offender Management Board, will continue to be charged with the development of standards and guidelines for the evaluation, treatment, and behavioral monitoring of sex offenders. Just going to check the question box real quick to see if anybody has any questions. Nope, looks like we're good. So moving on. Senate Bill 146, Modernized Statutes of Sexually Transmitted Infections. So this bill, as the Sex Offender Management Bill, or the Sunset Evaluation, was, I believe this bill was something between 40 and 50 pages long. It was a challenging read, and there were many changes to repeal statute, to change existing law. It was challenging. There were lots of stakeholders at the table on this one too. And so ultimately, where this landed is that this bill passed, and these sections that I have in front of you, these underlined sections, are specific to victims of crime. So for our purposes here in talking about the impact on sexual violence survivors, this is going to be the areas of interest for this bill. It was originally written to repeal felony enhancers for HIV transmission, including in cases of sexual assault. However, the bill was amended by the CDAC, the Colorado District Attorney's Council, to include the following. So I'm going to read that to you right now. It says, in cases of sexual offenses involving HIV, to file for an enhanced sentence, the court must find that the defendant had prior notice of his or her HIV infection and that the infectious agent of the HIV infection was in fact transmitted to the victim. So that mechanism that allows victim notification of the HIV status of perpetrators is still in effect. It is not repealed, and attorneys are still going to have that as a tool in prosecuting cases. So the implementation of this, it's actually pretty interesting, and that for victims of crime, this bill allows for testing of all sexually transmitted infections, not just HIV, of all sexually transmitted infections where there is a medically demonstrated risk of transmission. So the victim of a crime must also be provided with adequate counseling by a healthcare provider if risk of transmission exists, and an effort to prevent and treat transmission. So limitations of this bill, there were, and we're going to jump into this next. The next bill we're going to talk about is House Bill 1393. And at points in the process for Senate Bill 146, we believed that 146 was going to harmonize with House Bill 1393. And, but unfortunately, that did not happen. Although both bills passed, they did not harmonize. And again, we're going to jump into provisions for 1393 next. So currently, the statutory mechanism for HIV testing of perpetrators still lies far outside the window of opportunity to prevent transmission for survivors who are at risk. And offender testing will continue to be conducted subsequent to a preliminary hearing or after being bound over for trial. And so as we're going to see next, I'm just going to jump over to this slide to 1393. In order for a survivor to receive effective medication to prevent transmission of HIV, that medication needs to be given within 72 hours of exposure. And so, as we know, especially folks, law enforcement, community-based, systems-based, campus-based, as we know, no offender is at their preliminary hearing or bound over for trial within 72 hours. And so essentially, even though we still have that mechanism in Senate Bill 146 for victim notification of HIV transmission, that's all it is. It's just a notice. It's not effective in the intervention of preventing transmission of disease after the risk of exposure of potential transmission. So what House Bill 1393 does is provides a search warrant for communicable disease testing. It authorizes a court to issue a search warrant for a person's bodily fluids if a risk of exposure exists. This bill was originally designed for first responders, for those folks, let's say paramedics who come into contact with a communicable disease. And so what this bill allows for is the early detection of the potential for transmission of a communicable disease. And so CCASA's interest in this bill, if it were to be expanded to include cases of sexual assault, it would allow victims the possibility of additional testing options regardless of whether or not they chose to engage in the process of forensic evidence collection. It would allow victims the option of early detection, the ability to expedite the process of offender or suspect testing. It could provide possible evidentiary benefits for prosecutors, and most importantly, that if 1393 were expanded to include sexual assault survivors, they would have the option to know if an offender's status with enough time necessary to benefit from taking medication to prevent HIV transmission if the risk of exposure existed. So again, within that 72-hour window. And so, again, let's take a look at some of the current law that provides a person may be required to submit to a medical test for communicable disease if the person's or other person's bodily fluid came into contact with another person related to a conviction or finding of probable cause. So again, we're talking about preliminary hearings, we're talking about being bound over for trial, and by repealing these parts of the statute and substituting the provision that authorize a court order to test for communicable disease, the process is expedited and a victim can receive immediate medical assistance for the possibility of transmission. So this is a pretty key piece of legislation. We are very happy that this was passed, especially for those folks, those first responders. And so we're hoping to see what implementation of this looks like. How often are these warrants being issued by a judge? Are they being issued within a time frame like 72 hours? What happens as far as cases? How do the results of these tests, these early detection tests, how does it affect a case? And so we'll stay tuned, we'll stay monitoring the implementation of this specific bill, and perhaps it will be an issue that our membership will want to pick up moving forward, and see if we can expand it to include sexual assault survivors. So next, we're going to touch on the two bills that were championed by CCADV, and that is House Bill 1066. And what I'm going to do quick for folks, that was signed into law on April 15th. Yay, yay, win for survivors. Good job, CCADV. I'm going to pull up a fact sheet, I think, right here. Yep. This is provided by the CDAC, and it is specific to why this bill was needed. And I think, Rosa, we are going to be able to email this out to folks or post it so folks can have it as a handout. Okay, Rosa's shaking her head at me, and yes. So we're not going to go through this line by line, but I just wanted to show folks that we do have a fact sheet for you. I am not the expert on this particular bill, so I wanted to provide you with some information on what implementation is going to look like. But just a few key points. Something I found really interesting about this is that only 12 individuals have been convicted annually on average over the past 15 years for the charge of habitual domestic violence offender. And so what this law does, or what this bill does, is for those who commit and are convicted of more than 3 DV offenses in separate cases within their lifetime, their prosecutors are able to charge with the habitual domestic violence offense, where currently the law allows for 4 or more times. There was some conversation that this statute is applied unevenly throughout the state, and that by implementing this bill, that prosecutors would have the tools they needed to maintain public safety and prevent domestic violence batterers from continuing that behavior with multiple victims over a lifetime. So again, we're going to have the fact sheet up for you on that. We're also going to touch on assault by strangulation 1080, also led by CCADV. And if folks have any questions about either House Bill 1066 or House Bill 1080, please contact Lydia Walagorski. She is the Director of Public Policy for the Colorado Coalition Against Domestic Violence, and she is the one who helped organize legislative advocacy around both of these bills, and as you can see, both were sent to the governor's office, passed into law, and so big wins for survivors. Essentially, what this assault by strangulation bill is doing is creating a felony for strangulation cases. And another interesting fact I found here, we also have I have a fact sheet for you all right here from CCADV for those folks who haven't seen it. I found this to be interesting, this second bullet point, where it talks about only 11 pounds of pressure for 10 seconds is all that it takes to cause someone to become unconscious. And so with the awareness of the lethality, the severity of violence that strangulation has, that this now is going to be prosecuted accordingly to match that high level of lethality. I know Lydia pulled from several fatality reviews, the impact, the long-term health consequences of strangulation, both on adults and children. Also noteworthy about this bill is that changes will equally apply to adult and child victims. So where do we go from here? That's about our wrap up of everything that happened at the Capitol this legislative session. And so where we go from here, I think this might be a good time to do a kind of informal poll. We're going to be, as the slide says, we're going to be sending out a policy priority survey. And what that is based off of are the current trends in Colorado that we're hearing from our folks who are doing the direct service work, trends around the country, and things that happened at the Capitol this past legislative session to try to inform our work for 2017. So if I can, one more poll. I appreciate you guys. What policy issues would you like to see CCASA prioritize next year? So again, we talked about youth sexting. That is likely to be an area of interest for our members. Felony background checks for youth sports volunteers and coaches. Expanding the list of crimes that require DNA collection upon conviction. Timely offender testing for early detection of risk of HIV transmission, and sex offender policy issues. So I see folks are participating in the poll. I appreciate you. Again, we're going to be having a larger, more extensive poll coming out for our membership. I hope to have that information analyzed and ready for discussion before our next policy committee meeting, and hopefully too before the Colorado Advocacy and Action Conference, which is going to be in Vail June 6th. So I'll give folks just a little bit more time to answer the question. What I'm seeing, which is very interesting, is that felony background checks for youth sports coaches and volunteers, as well as sex offender policy issues, looks to be the two priority issues that this group has identified. We'll go ahead and share that with you now. And I'm glad that folks sought interest in the felony background checks for youth sports. So there was a last-minute bill that was introduced, and I cannot remember the bill number. I know it was a House bill. It was introduced by Representative Singer, and I believe there was work done in this area last session to try, and maybe even 2 sessions prior. This seems to be an issue that keeps coming up, is to require felony background checks for those folks who are volunteering, participating with youth sports. And for the life of me, I can't seem to understand why that bill continues to meet opposition and get defeated. So we will certainly be working with stakeholders to try to determine what the roadblocks continue to be and how we can ensure that children are, you know, in the most safe and responsible areas they can when they're enjoying their sports programs and organizations. And so one interesting point about felony background checks is that, as we know, if we, again, let's go back to that number, about only 6% of sex assault cases are actually prosecuted. So, you know, I'm not a statistics analyst by any means, but if we try to parallel that into saying that then maybe only 6% of sex offenders are going to show up on a background check, it's not the most, it almost gives a false sense of security that if these background checks exist, that means that there is no sexual predator that's able to, you know, access children, where that simply just isn't true. However, it is incremental change in the right direction, right, to ensure that our communities are safe, that our children are safe, that they're able to enjoy organized sports and organized activities, and that those volunteers and coaches who participate in those organizations are, you know, the people that we can trust with with our children. And so thank you for those who participated in that survey. I will certainly hold on to these results as we send out the larger priority survey for SurveyMonkey. And I believe this is my last slide, and just a couple of updates for folks to get involved. We have the Colorado Advocacy and Action Conference coming up on June 6th. We've got the CCASA Public Policy Committee. It meets every third Tuesday of the month between 11:30 and 1. There's also a dial-in option for those folks who are not located in the Denver metro area, or for those folks who are in the Denver metro area who can't make it to the Rosandom Center. So we do have a dial-in option. And then if you have any specific questions, any questions about cases for me, this is my contact information, raana@ccasa.org, and then my direct phone number. We are in a little bit of transition right now. We're moving offices, so I think the best way to reach me is going to be through email. And I'm going to go ahead and open up the questions box, see if anybody has any questions about the legislation that we covered today. And if not, if you want to just email me privately or at a later date, if you have any questions, if a case comes up and you think that one of these bills that was passed during the session could be beneficial to your case, please reach out. We are here. We're here to support you guys. And also, I just want to say thank you again to all those folks who participated in the legislative policy work this session. It was my first session in Colorado, and so it will always be a very special session for me. But I do appreciate the support from our community-based advocates, our law enforcement, our state attorneys, our systems-based, our SANE nurses. Our SANE nurses, I know there's some of you on this call, our SANE nurses rocked it in the strangulation hearing. So if any of you were there to testify, thank you. And we're going to turn that phone off.
All right, thanks, Raana. Thank you so much for presenting. I think that folks really got some good information out of that. I saw a last-minute question come in that was asking, will these slides be available for review? Yes, we will be including a PDF copy of all of the slides, as well as the handout information for you to review later with your staff, or, you know, like Raana said, if something comes up and you're just not sure if anything that's kind of gone up will pertain to that, we'll definitely send out all of that information to you. I'm just going to check and see if there were any other questions. Oh, okay, sounds good. All right, guys, thank you so much, Raana, and congratulations on finishing your first legislative session. Yay! It was awesome. We really liked it. And thank you guys for participating in this webinar. You know, a quick plug for next week's webinar. We are having a webinar next week on the 25th, same time, moving forward towards inclusiveness, how we can incorporate men into our day-to-day work, which should be exciting. So look out for the webinar link so you can register for that. But again, we will be sending up a follow-up email with all of the slides, all of the information that you've heard today you'll be able to access. One last thing, there is an evaluation after this webinar. Please fill out the evaluation. As you all know, everything we do is because of what you all tell us that you need. So please fill out the evaluation. It helps us to get better and helps us help you. So I hope you all enjoyed the webinar. Have a great day today, and we will talk to you soon. Bye, everyone.
Bye.